In public session. The purpose of this morning's engagement is to meet with the Data Protection Commission in order to discuss the Commission's role in light of the introduction last year of the General Data Protection Regulation and to discuss data protection issues in general. And we're joined this morning by Ms Anna Morgan, Deputy Commissioner, you're very welcome. Ms Jennifer O'Sullivan, Deputy Commissioner, you're also very welcome. And Mr Cathal Ryan, Assistant Commissioner. You're all very welcome here this morning, and we thank you for taking up the invitation to address this very important matter with us. Before we continue, I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person or persons or entity by name or in such a way as to make him or her or it identifiable. Members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. And if I just before inviting, I believe, is it Anna, are you making the opening statement? But before I do, is just again to ask everybody, including our visitor, to please switch off your mobile phones. They interfere with the recording equipment here. So I would now like to invite Ms Anna Morgan to make the opening statement on behalf of the Commission. Thank you.
Chairman, Deputies and Senators, good morning, and thank you to the Joint Committee on Justice and Equality for the invitation to attend before you today to discuss the recent annual report of the Data Protection Commission for the period from the 25th of May to the 31st of December 2018. I am one of 5 Deputy Commissioners at the Data Protection Commission, the DPC, and Head of Legal Affairs. In attendance with me today are Deputy Commissioner Jennifer O'Sullivan, who is Head of Strategy, Operations and International Affairs, and Assistant Commissioner Cathal Ryan, who has responsibility for the consultation function in relation to the public sector and law enforcement matters. As members of the committee will be aware, 2018 was a momentous year for data protection in Ireland and across the EU, with the General Data Protection Regulation, the GDPR, entering into application on the 25th of May. This new legal framework has brought about transformative changes to the data protection regulation system, enhancing the data protection rights of individuals, cementing the responsibilities of organisations when processing personal data, and providing data protection regulators with a new toolbox of hard-edged enforcement mechanisms. While the GDPR is an EU regulation, it allows Member States to give further effect to certain aspects of the GDPR's rules at a national level. And this was done in Ireland by way of the Data Protection Act 2018, for which this committee carried out pre-legislative scrutiny in mid-2017. The DPC would like to acknowledge the valuable work carried out in relation to the general scheme of the Data Protection Bill 2017 and the comprehensive report which was produced by this committee as the outcome of that process. The Data Protection Act 2018 forms a vital piece of the Irish data protection regulatory framework. In essence, the 2018 Act serves 3 overarching purposes. Firstly, it gives effect at national level to the GDPR in relation to those areas where a margin of manoeuvre was allowed for Member States to specify the GDPR's rules, such as the age of digital consent. Secondly, the 2018 Act transformed the Law Enforcement Directive into Irish law, and that directive provides a separate set of data protection rules in relation to the processing of personal data by law enforcement agencies for the purposes of the prevention, investigation, detection or prosecution of criminal offences or the execution of criminal penalties. Thirdly, the 2018 Act ended the existence of the Data Protection Commissioner and replaced it with the Data Protection Commission, which is a body consisting of at least 1 and not more than 3 people, each of whom is a Commissioner for Data Protection. Together, the GDPR and the 2018 Act provide the DPC with a greatly strengthened suite of investigative, authorisation and enforcement powers. Under the previous legislative framework of the Data Protection Acts 1988 and 2003, the enforcement powers available to address contraventions of the law were essentially limited to the issuing of enforcement notices. However, under the new regulatory regime, the DPC may issue reprimands and warnings and impose administrative fines up to a maximum of the higher of €20 million or 4% of annual global turnover. The DPC also has the power to issue directions to organisations to comply with requests by data subjects to exercise their rights, to bring processing into compliance with the law, and to issue bans on processing or data transfers, amongst other powers. The DPC's enhanced medley of powers is reflective of its much increased range of statutory functions under the GDPR and the 2018 Act. These include awareness raising of rights and risks for individuals and of the obligations on organisations which process personal data, advising the legislative function of government on certain legislation, and cooperating with other data protection supervisory authorities in the EU to ensure the consistent application of the GDPR. At the core of the DPC's obligations as the regulator and enforcer of data protection is the obligation to handle every complaint relating to data protection which is lodged with the DPC and to investigate such complaints to the extent appropriate. In this regard, a significant change from the previous legislative regime is that the DPC is no longer obligated to issue a statutory decision on every complaint where it has not been possible to reach an amicable resolution between the complainant and the organisation concerned. While the DPC must now handle the complaint, it may address the complaint through a number of different actions, including, amongst other things, issuing enforcement notices to the organisation concerned, requiring them to take particular action, issuing advice to the individual concerned, brokering an amicable resolution, or, where appropriate, commencing a statutory inquiry. The DPC has already found that the flexibility offered by the new national legislative regime in this regard has allowed it to make much more efficient use of the resources it has in seeking to vindicate the rights of individuals, rather than having to dedicate significant resources to drafting and issuing statutory decisions. This efficiency is particularly significant in the context of the increased volumes of complaints that are now being received by the DPC compared with the pre-GDPR period, which I will discuss in a few minutes. It should be noted that while the GDPR and the 2018 Act have been applicable since the 25th of May 2018, the new legislative regime does not apply retrospectively, and rather the previous legislation, the 1988 and 2003 Acts, have been retained in law for certain limited purposes, including for dealing with complaints which relate to data processing prior to the 25th of May 2018, and also for investigations which had already been commenced prior to that date. The DPC continues to deal with a number of complaints and issues which must be resolved under the previous legislative regime, including complaints which continue to be received in relation to the pre-GDPR period. The DPC's remit as a regulator is somewhat exceptional in that it applies regardless of the industry and sector where any organisation, public or private, with the sole exception of the courts, is processing personal data. However, despite our broad jurisdiction to supervise the processing of personal data, it's important to point out that we do not have regulatory competence in law for many contemporary issues, such as so-called fake news, online content moderation, and internet safety. Since the GDPR, data protection has undergone what the Commissioner has referred to in the 2018 annual report as the GDPR effect. In other words, the mobilisation of individuals to action to tackle what they see as misuse or failure to adequately account for and explain what is being done with their data. This is being reflected in the significant increase in complaints and queries received by the GDPR during the period from the 25th of May to the 31st of December 2018, with more complaints received during that 7-month period than in the full year of 2017. Equally, this period has seen a doubling in the number of data breach notifications received by the DPC, with the now mandatory requirement on organisations to report data breaches to the DPC within 72 hours. In light of the requirement on the Government to consult the DPC in relation to certain new legislation which concerns data processing activities, there has also been a very significant increase in the DPC's workload to review and provide observations on new and draft legislation, with 25 pieces of primary or secondary legislation coming to the DPC for review during this 7-month period. Critically, the DPC has commenced a considerable number of statutory inquiries under the GDPR during 2018, concerning systemic issues in the commercial and public sectors. 15 of those inquiries relate to the multinational technology sector, examining issues involving processing by internet platforms, such as the right of individuals to access their personal data, transparency, the legal basis for processing, and the security and safeguarding of users' personal data. A further 33 domestic statutory inquiries were also commenced during 2018, examining issues such as the use of CCTV by local authorities, data breaches by TUSLA, and the role of the Data Protection Officer in the Department of Employment Affairs and Social Protection. These inquiries are each complex and challenging, raising multiple data protection and legal issues, and the DPC has allocated considerable resources to investigating these issues of systemic public importance. It is expected that the majority of these inquiries will be concluded during 2019. During the period in question, the DPC also took successful prosecutions against 5 organisations for 30 offences in relation to direct marketing under the regulations known as the e-privacy regulations. As the committee members will be aware, the DPC's functions and responsibilities are not solely reserved to domestic regulation of data protection. Under the GDPR, the DPC has the role of the lead supervisory authority under the new one-stop shop regime for multinational organisations which have their headquarters in Ireland and meet objective criteria to demonstrate that this is their main establishment in the EU. This means that in addition to handling and investigating complaints from data subjects in Ireland related to those organisations, the DPC also must do so for data subjects in other EEA jurisdictions, including when the complaints have been lodged originally with other data protection authorities. The DPC is responsible for coordinating a consensus on a complaint or a possible infringement of the GDPR with all of the other EEA data protection authorities who are said to be concerned by the issues in question under the cooperation and consistency mechanism of the GDPR. The DPC's activities in its role as lead supervisory authority represent a considerable proportion of its workload in cooperating with other relevant data protection authorities and keeping them up to date in relation to ongoing investigations and complaint handling. In addition, the DPC, as a member of the newly established European Data Protection Board, the EDPB, which comprises all the EEA data protection authorities, devotes significant resources to travelling to the monthly EDPB plenary meetings and the frequent meetings of its 12 subgroups, with upwards of 100 meetings planned for 2019, all with the aim of securing consistent application of the GDPR. The very serious expansion of the DPC's remit at national and EU level and the huge increase in workload volumes came as no surprise to the DPC. In the year leading up to the application of the GDPR, the DPC carried out an extensive evaluation and change management process to map the operational and resource impacts of the new functions which the DPC was to take on and the anticipated increases in volumes. The government's increased funding for the DPC during 2018 of €11.7 million, of which €7.3 million represented pay allocation, enabled the DPC to respond to its need for greatly elevated staffing levels and to recruit some 25 people during the course of 2018, bringing staff numbers to 110. The DPC targeted specialist recruitment during this period, running 5 specialist competitions with the support of the Public Appointments Service, enabling it to appoint new staff in the legal investigations and technology areas, amongst others. These appointments were critical for the DPC to continue to build a highly skilled workforce to deliver its expanded regulatory remit under the GDPR. The DPC has continued to increase its staffing levels in the early part of 2019, and the staff headcount currently stands at 135, with further recruitment this year expected to take the DPC to 160 staff by the end of 2019. Strategically, the DPC continued to prioritise its awareness-raising activities during 2018 with an ambitious outreach programme of participation in national and international events, as well as issuing public information and guidance, undertaking significant media engagement and launching a new website. In conjunction with these ongoing activities, the DPC launched a high-profile public consultation at the end of 2018 on the processing of children's data and the rights of children as data subjects. This is with a view to producing guidance materials for children and young people and for organisations that process their data, and encouraging industry to draw up codes of conduct to promote best practices in this area. A further stream of this consultation launched in early 2019, which aims to directly gather the views of children and young people in the classroom through the delivery of a specially created lesson plan. Both streams of the DPC's consultation are currently running with a closing date of Friday the 12th of April. At a broader organisational level, the DPC commenced a significant project in late 2018 to develop a new 5-year regulatory strategy, which will include extensive external consultation during 2019. This new regulatory strategy will guide the DPC in prioritising its work and strategically balancing competing demands in the exercise of its regulatory powers, and will give greater insight to stakeholders on how the DPC intends to regulate. Like 2018, 2019 will be a big year for the DPC with these consultation projects, its continued expansion and operational enhancement plans, and particularly with the first wave of decisions arising from its ongoing statutory inquiries anticipated in the latter half of the year. The DPC is committed to firm and robust regulation and looks forward to continuing to break new ground under the GDPR and the 2018 Act during 2019. We thank the committee members for their attention, and we would be happy to take questions.
Thank you very much indeed for that. So I have an indication, I think, from almost all of you at this point, and Senator Martin Conway leads the pack. Off you go, Martin.
And I'd like to welcome the Assistant Commissioner and her colleagues here this morning. And I suppose I'm just going to ask a couple of questions based on my own experience of GDPR as a public representative. And I'm sure our visitors will be aware that at the very end of the GDPR legislation that there were a number of amendments that were brought in by the government in the Shannon before the legislation was implemented in terms of public representatives and members of the Oireachtas and dealing with statutory bodies. And I suppose my question, I'll give an example, because I actually believe that GDPR, that a lot of organisations are not respecting the amendments that were brought in at the very end in terms of dealing with members of the Oireachtas. And I'll give you an example. If my office receives a query about a third level grant and they engage with SUSI, which is the organisation that deals with third level grant applications on behalf of the government, the client has to go on the SUSI website and name me as an advocate. Now, in my view, that's a clear breach of the GDPR legislation. I'd like to know, has the Assistant Commissioner or her colleagues come across this situation? And have they ever launched an investigation where government departments are actually using GDPR as an excuse in terms of engaging with people? Have they ever carried out an investigation on organisations that perhaps are implementing the GDPR legislation in a way that's not appropriate? Are they aware, or have they policed, or have they looked at any examples of where the amendments that were brought into the legislation in terms of how public representatives engage with various departments, how that's been implemented, either at local authority level or government department level?
Thank you, Senator. Who would like to take up any of you? Which would you like to, Anna, take the first response? And if any of your colleagues to feel fully at your ease, if you want to add something, just indicate. Thank you.
Thank you, Chairman. Thank you very much to the Senator for the question. Maybe to deal with the latter issue which you raised, first of all, in general terms, and then I will hand over to Assistant Commissioner Ryan in relation to the specific query raised. So, Senator, you have referenced the phenomenon of the GDPR being used potentially as an excuse to deal with certain issues. This is certainly something that the DPC has been aware of in many contexts since the GDPR came into application, where the rules in the GDPR have been used by a whole range of sectors to, I suppose, potentially sidestep obligations that may otherwise apply to them. We have had to do a significant amount of myth busting, and we've recently published a blog on our website in relation to what the GDPR does and does not say. So I think the issues that you raise are certainly very pertinent in the context of the first 10 months of application of the GDPR. In relation to the substance of your question, which I understand concerns Section 40 of the 2018 Act, and the activities of publicly elected representatives. I'll hand over to Mr Ryan to address that question in more detail.
Thank you, Anna. Yes, Senator. I think just from the outset, we identified this issue as a very important issue very early on, even just literally post-GDPR. We noted there were issues in terms of making public representation. And it's important to state that it's a really important democratic function. So we were very aware that we needed to discuss this matter with not only yourselves in the houses of the Oireachtas, but also with the local authorities, with the departments, which is what we did. So behind the scenes, I carried out a lot of consultation with various committees, local authorities through the LGMA, to get a sense of the issues on the ground. And following that, what we identified was that there was an inconsistent approach being used by either local authorities or departments in how they were approaching Section 40 of the Act. So with that in mind, and as you've rightly pointed out, there is a sense that people were using GDPR as an excuse, or departments were using an excuse. We wanted to tackle and implement a common sense approach to Section 40, which we have done through publication of guidelines. The guidelines would have been sent to every member of the House of the Oireachtas. Those guidelines were also issued to all local authority public sector departments nationwide. And in effect, what the guidelines are suggesting is that a democratic representative has to take some responsibility for the public representation that they are making in terms of their engagement with their constituent. But on the basis that they have done so, the department or public sector body should take their word or a letter, written letter, that they actually have a legitimate public representation to make. So if you read the guidelines, which were published late last year, I believe around December, you will get a real sense of what is required. Following the guidelines which we published, we then went back to those bodies and we encouraged those bodies to come together to form a kind of standard approach. So for example, I've attended a DPO network committee with the LGMA for local authorities, and it's my understanding that they are going to develop a code of conduct based on these guidelines. So as you're aware, there's 31 different local authorities that may be doing 31 different ways of public representation.
I'll be frank with you. I don't believe that your guidelines are good enough. And I don't believe that your guidelines respect the spirit of Section 40 of the GDPR legislation that we put through the houses of the Oireachtas. And thirdly, I don't think that your guidelines respect the unique political situation, electoral situation that we find ourselves in. There are only 2 countries in the world that have a similar electoral system. Ireland, PRSTV system, Ireland and Malta. So that's the first point. The amendments were brought in the Seanad to deal with the uniqueness of our political system. And I spoke to the staff in my office yesterday ahead of this meeting, and I asked them for one example. Do you think, and the example is Susie, which I outlined earlier on, do you think it's acceptable that a member of the Oireachtas should have to ask a client to go on the Susie website and name them as an advocate, given the fact that we have their PPS number, we have their date of birth, their address, and all other relevant references? Do you think it's acceptable that a member of the Oireachtas should have to demean themselves to ask a client to go on a public body website and name them as an advocate?
Put simply, no, is the answer. And the guidelines, if you read those guidelines and you assess them, that is what they're suggesting. They're just suggesting a common sense approach. It appears to me that perhaps there's an overly bureaucratic approach being taken in terms of what Susie are doing. But we also have to be mindful as a regulator that the principle of accountability means that each data controller has to make an assessment of how they are going to approach public representation. So our guidelines were there to influence how that assessment is made. And very much what my plan is, that the guidelines are being digested at the moment because they only issued in December of last year. And what we're hoping then is to follow up once public sector bodies, once local authorities have considered them, we are then going to follow up in terms of encouraging a standard approach, but a less bureaucratic, common sense approach. Now, we can't get into every detail of what they'll do in terms of safeguarding particularly sensitive data. But one thing we can do is, it appears to me on the SUSI application that you mentioned, that, yeah, but that's a common sense one where if you write into SUSI, that should be the public representation verified without an individual having to fill in a form which is 5-6 pages long. Sometimes by doing so, it delays the process where the actual objective of the public representation can't happen because of a delay in bureaucracy and filling out forms. So we've encouraged bodies to read our form, read our guidance, and to apply it accordingly. And we anticipate that the guidelines will work. Obviously, there will be individual things that will happen, individual case-by-case basis that we'll have to look at. But in the main, it is expected that public sector authorities will apply a common sense approach to this very important function. If there are issues in terms of interpretation of our guidelines or an overly conservative approach being taken by a public sector authority, of course we will look at it, but we also have to bear in mind that we can't compel a body to share information. It is their assessment based on the principle of accountability.
Well, I would actually challenge you in terms of the fact that you can't compel, because if a member of the Oireachtas breached data protection, you would be able to carry out an investigation. But what I would suggest to you, there's no point in us dominating the discussion. What I would say to you is, I think that you have a duty of care and a responsibility to come in here and perhaps have a workshop and engage with members of the Oireachtas in terms of a practical where we can give you practical examples of where our work has been impeded by departments using GDPR as an excuse. So perhaps it's something that you and your senior management team can talk about and come back to us maybe with a plan. Absolutely,
Senator. And I suppose just to let you know, we actually had an open invitation to do just that following the guidelines, and we communicated that that offer to the House of the Oireachtas. We've also done it in terms of meeting the councillors at one of their annual conferences lately in Longford, the AILG, who you'll be familiar with. So we actually have already carried out conferences and workshops of this nature, and we're very much open to continuing that work and spreading the message of a common sense approach to public representation. Thank you.
Could I just add, before Senator Caoimhghín, who I understand has to go off, but I think it is important to emphasise, he used the word impeded, and as chair of this committee I want to say to you that's not just an isolated individual experience. I'm saying in full support of what Senator Conway has said, that this is a universal experience, and impeded is exactly what's happening in terms of our representative function. And it is a very, very serious matter, and I cannot underscore it strongly enough for you here this morning. So I thank you, Senator, for that contribution.
If this engagement achieves nothing else but respects the fact that people who are elected to public office have a mandate and have the confidence and the support of the people who elect them, and the reason that Section 40 was brought in, because I lobbied significantly for it, and if you actually go through the record of the House, you will see the engagements and contributions at both committee and report stage. It was done because we are in a situation in this country where we get thousands, politicians get thousands of representations on specific issues, whether it's social welfare, health, education and so on. And I really do believe that you have a job of work to do. So if this engagement achieves nothing else but it re-establishes the respect for public representatives among public bodies, I think it will be a good engagement, Chairman.
Thank you, Senator. Deputy Jack Chambers, please.
Thanks, Chair, and I'd like to thank everyone for being here. And like Senator Conway said, I think perhaps if you had a specific maybe email or line that we could, public reps could submit a something that is restricting our ability to do a representative function. If that was communicated to us, I think it would be a helpful way for you to just go directly to whatever the body is or the person who is probably going beyond what the GDPR says. I think that would be helpful. Just my questions, I just want to ask, just regarding your relationship with, I know you mentioned in your statement about your relationship with just want to know what your relationship is with the various tech companies. What engagement have you had with them? What's the level of cooperation that you've had? Do you give notice to them if you're conducting an audit, or do you do randomised audits of their data processing? Could you just give us an indication about what your relationship is with them on a day-to-day basis?
Thank you very much for the question, Deputy. In general terms, as the committee members may be aware, the DPC has always reinforced the importance of having an ongoing dialogue with multinational and technology companies in order to drive better awareness and increased understanding of the rules in relation to data protection, and particularly in relation to the interpretation and position of the GDPR in relation to those rules. So that ongoing dialogue that we have with companies serves a very important function, and it has resulted in, I suppose, us becoming aware of the potential rollout of products and services where we can input into the data protection compliance of those products and services, and potentially influence the technology companies in relation to the manner in which they intend to move forward if we perceive that there are risks to data subjects. In terms of the inquiries, the statutory inquiries that we have open, that's a completely different process to our consultation and engagement function. Those statutory inquiries, of which there were 15 opened into the multinational sector during 2018, have as their ultimate objective to reach a decision on whether or not there has been an infringement of one or more of the GDPR rules. So there are a number of stages to those processes which are all quite formalised, and our annual report refers to, I suppose, the overall linear process, and the members of the committee will see a graphical depiction of that on page 30 of our annual report. But essentially that involves the stages of information gathering, evidence collection in relation to the scope of the particular inquiry, applying the law in relation to the evidence that has been gathered to assess whether or not there does appear to be an infringement of the legislation, and then the formal decision-making process whereby the decision-making function in the Commission is engaged to make a formal decision which has status under the 2018 Act, and to then consider whether or not, in light of that decision as to whether or not there has been an infringement, a corrective power should be applied. So that is a very different process to the supervision function. I might hand over to my colleague Jennifer O'Sullivan to talk a little bit more about the supervision of multinational companies, and particularly in relation to those statutory inquiries.
Yes, so we have, as my colleague mentioned, we opened 15 inquiries in total during the period of our recent annual report into those large multinational technology companies. These inquiries cover a range of very fundamental matters of data protection. Very fundamental transparency obligations are being examined. Fundamental elements of the data protection law in terms of the legal basis for processing are being carefully looked at, and also in light of the breaches that were reported by 2 of those companies during that period, we are examining the organisational and security measures of a couple of those companies under the format of a statutory inquiry. In terms of the relationship with the organisations, as my colleague mentioned, we have a multifaceted approach. Some of our engagement with them is in the context of consultation around their new products. Also very important for us is to get a better understanding of their business model, of the context in which they work, because that's very important and useful for us as regulators in terms of the efficacy of our advice, but also our decision-making and judgment in separate contexts. So there are some of the inquiries we have underway already, and we are also, since the year started this year, we are also in the process of opening further inquiries.
Okay, and obviously 7 of the 15 complaints are against Facebook, and then 2 of the 15 are against WhatsApp, which is a company under the ownership jurisdiction of Facebook. So that's 9 out of 15. When do you expect fines to be issued or decisions to be made? So I know, for example, with Google in France under EU privacy rules, they've made decisions and they've issued a fine to Google of 50 million. And I suppose Google have their headquarters here, for example. So when do you expect decisions and outcomes to be made under GDPR investigations? I suppose people are awaiting that. And what's the timeline or the trajectory for the decision-making process to conclude?
Yes, so you're right, Deputy. We have 7 inquiries into Facebook, 2 into WhatsApp, and actually a further inquiry to Instagram, which is also owned by Facebook. So that represents a significant proportion of our formal inquiries into those companies, some of which were in response to complaints, as you mentioned, but also some of those inquiries we undertook at our own volition, having examined the context and the wider situation. In terms of the timeline, my colleague outlined the very structured, formal, robust and consistent approach we need to take to these inquiries. The latter elements of that process include engagement with our colleagues around the EU in the format of the European Data Protection Board. So we're obliged to consult with those colleagues as we near the decision-making process. So we have to submit a draft decision to those colleagues, and they are entitled to examine that decision and submit reasoned and relevant objections to us. We need to take account of those objections, consider whether they do have a bearing on our own draft decision, and seek consensus on it. So that process takes time in its own right. The situation with our French colleagues' decision on the Google case was somewhat different. Google actually only established itself as a controller in Ireland in January this year. So prior to that date of January 22nd, any data protection authority around Europe with competence could have examined a complaint brought to it and taken enforcement action, which is what our colleagues in the French DPA, the CNIL, did. So they received a complaint that was submitted to them at the end of May, just at the point of the GDPR coming into effect. There was collaboration and discussion with ourselves, the CNIL and other members of the EDPB at the time to make sure we were carefully examining the question of competence, given that Google hadn't established a data controllership in the EU at all, in fact. After that careful examination, we did conclude that it was a matter for the CNIL to take up directly, but because it didn't fall under that definition of cases that are examined under the one-stop shop model, the CNIL did not have to go through those stages of consultation with colleagues around the EU and EEA on the case. So it was a much shorter process, and hence they were able to announce their decision on the 21st of January this year. So for the inquiries that we have underway, we are actually facing into that consultation process with those colleagues.
Just in terms of in your statement in point 7 and the changes to the data protection legal framework, you point out that you've no regulatory competence in law for many contemporary issues such as fake news, online content moderation and internet safety. As a Commission, do you have a view on a Digital Safety Commissioner and on the whole debate around fake news? Have you looked at what's happened elsewhere and do you have any view on that?
Thank you, Deputy. In relation to the Digital Safety Commissioner, we have noted that public consultation has been launched by the Government and is ongoing at the moment in relation to the bringing into effect of legislation in relation to online safety, and that legislation is also intended to transpose the EU Audio Visual Media Services Directive as well. Insofar as there is an intersection between data protection and issues concerning online safety. I think this really occurs in the context of children's issues in particular. And as data protection authorities now have a newly enunciated obligation under Article 57 of the GDPR to drive awareness in relation to issues around children's rights and the risks for children in relation to the processing of their data by organisations. We have been exploring this issue over the course of 2018 to try to identify methods by which we could better raise awareness and better drive good practices amongst organisations, particularly in relation to the online sector. And with a view to doing that, as I referred to in the opening statement, we launched a consultation at the end of 2018, which has two limbs to it. The first limb is a written public consultation, which is aimed at adult stakeholders, so parents, educators, child protection organisations, children's representative groups are all encouraged to take part in that, and that consultation engages a range of issues from transparency information to children so that they can understand what is happening to their data when they engage in the context of online platforms and apps. It covers issues such as the appropriate age at which a child should be able to exercise their data protection rights, because of course the GDPR is silent in relation to that particular issue, but we're very conscious of the UN Convention on the Rights of the Child and the particular provisions that relate to children having a right to have a say in light of their evolving capacities in relation to matters that directly concern them. Equally, our consultation also relates to issues around direct marketing and advertising to children and the use of children's data in that context, along with very topical issues which the committee members will be aware of in relation to Article 8 of the GDPR concerning the age of digital consent and issues around age verification and the verification obligations on online organisations to establish that consent to processing has been given by the holder of parental authority. So in light of all of those issues that have been very to the fore, I suppose, of public discussion over the course of the last 2 years in particular, we launched that consultation. But we also were very keen to engage with children directly, and for that reason we decided that quite uniquely we would launch a further stream of our consultation, which was aimed at garnering the views of children in particular. And so we explored different methods by which we could most effectively do that, and we decided that participation in a standard written consultation was potentially not the most effective way to gather children's views. And so we designed over the course of 2018 from scratch a series of lesson plans which aim to educate children in a classroom setting around basic principles of data protection, to make them aware of their rights and the risks when they are sharing information in an online setting. And so with those education materials, they have been sent to every single school in the country and to all of the youth reach centres, and the time frame for that consultation is still ongoing, and we have asked teachers in schools to participate, obviously on a voluntary basis, in delivering those lesson plans. And the ultimate output of those lesson plans is a kind of an exercise whereby teachers can gather the views of children in relation to the topics that have been discussed, and they can share their own opinions on issues such as at what age they should be able to for example, make an access request to an organisation or look for erasure of the data that they have shared online. So that consultation is ongoing, and at the end of that process, as I mentioned, the intention is to firstly produce best practice guidance for organisations in relation to the use of children's data, and also, very importantly, produce a guidance for children which will be in accessible and easy to understand language, and will help them to, I suppose, better comprehend the issues around sharing of information online. And I suppose finally, connected to that, and in light of our obligation which has been set out in the 2018 Act to encourage the drawing up of codes of practice by industry in relation to a range of issues concerning the processing of children's data, we also aim then to use the outputs of that consultation to encourage industry members to come together and to produce those codes of conduct.
Just finally, Chair, just on the digital age of consent, how is that being implemented generally? Have there been many complaints made vis-a-vis the legislation or breaches of the legislation, or how are they? Can you give us information about if there's any investigations on that? And then just finally, in terms of your general allocation of resources, do you feel your present resource allocation is proportionate for the role you have to play in the context of the multinational companies? Your Commissioner Dixon has outlined publicly about her concerns about the general allocation, staff space and other matters, and can you update us on that as well? And just final question relates to, we've Minister Stanton in about gambling companies next week. There's a lot of concerns with gambling addicts who are probably the most vulnerable, a very vulnerable cohort in society, who are being targeted, because of their previous activity, and there may have been data breaches there. I know there's been concerns and matters submitted to yourselves about that. Are there any active investigations against gambling companies and how they use, very complex technical tools to actually target people in that regard? Thanks again.
Please.
Thank you very much, Deputy. Firstly, in relation to the age of digital consent, this relates obviously to Article 8 of the GDPR, which has its challenges in itself in relation to the obligation on organisations to take reasonable steps to verify that consent has been provided by the holder of parental responsibility, where consent is the basis for processing children's data. In other words, anybody under the age of 16 in Ireland. This goes to, I suppose, one of the core issues that we are looking at in terms of our consultation around how organisations can adequately verify age to identify whether a child falls below or above that threshold, and then connected to that the obligation on organisations and online platforms to verify parental consent in relation to that processing. So there have been a range of different methods that have been used by organisations, some of which have been based on the COPPA Act, which you may be aware of, which is the Children's Online Privacy Protection Act in the US, and that sets out that's a very detailed piece of legislation specifically on these issues, and that sets out a range of different techniques whereby organisations can potentially attempt to verify that the holder of parental authorisation, the holder of parental responsibility has given their consent to the processing. And for example, one of those methods that's talked about in that legislation is the payment of a micropayment on a credit card, the theory being that a parent, it will be somebody over the age of 18 who will have access to a credit card. And we are aware that certain online organisations and companies did roll out that as a means of verifying whether consent had been adequately given. And we're also aware from those companies that they have directly received a certain amount of criticism from parents who believed that the gathering of this additional financial information was excessive and was disproportionate to the obligation on the organisation to verify parental consent. So it's a very complex issue, and it's one that we intend to fully explore within the context of our consultation, and particularly address in the best practice guidance that we intend to issue after the close of that consultation. Just turning to your question in relation to the allocation of resources and staffing levels for the organisation, I think our Commissioner has mentioned on a number of occasions that from 2014 onwards the Government committed to increasing the funding of the DPC and in that year, and to keeping that under review, which it has done so since then, and our budget allocated on an annual basis has increased every year since 2014. We are now at a level where our budget for 2019 is 15.2 million, and that has increased quite dramatically from the 1.7 million that was the budget allocation for 2013. So we're very much of the view that adequate funding for the Data Protection Commission is absolutely critical for it to continue to build its capacity and to enable it to perform as an internationally respected and effective and robust regulator. And so we have very much welcomed the increases in budget which have happened over the course of recent years. In terms of the impact of that budget on staff, as I mentioned in our opening statement, we are currently at staffing levels of 135. We intend to recruit further staff by the end of this year in specialist areas, particularly in the legal and technology and investigatory functions, which are priority areas of recruitment for us. And we intend to reach 165 by the end of 2019 based on this year's current budget allocation. We also anticipate that we would need staff numbers of around 190 by the end of 2020 and 220 staff by the end of 2021 based on our analysis of the trends to date in terms of the increasing volumes of matters that we are dealing with. So certainly the funding issue remains vital to us being able to continue to perform in the manner that we must do under the GDPR and to be able to fully, I suppose, perform our functions under the expanded remit of the new legislation. Finally, in relation to your question on gambling, obviously we do not have a regulatory remit in relation to the gambling sector per se. However, there will be or there may be many situations where personal data could be used in the context of the gambling sector. And I think some of the issues that you're referring to might relate to online behavioural advertising, which is an issue that the Office has been looking at in a number of different contexts. And I might just hand over to my colleague Jennifer O'Sullivan just to consider the issue of online behavioural advertising further.
Yes, thanks Anna, and thanks Deputy for the question. So the Office is examining this issue using a multi-pronged approach. At the European level, we're working with our colleagues in the European Data Protection Board in a particular subgroup of that board, which is examining social media and the targeting of individuals through social media. So we're working on that in a very universal way, which would include the targeting of vulnerable individuals, such as gambling addicts, as you mentioned. The DPC itself is also examining the issue very comprehensively. During 2018, we established a technology leadership unit, and they're doing significant research into the area of advertising technology, as it's known, or ad tech, which would touch on some of the issues you mentioned. We're also examining complaints and submissions from various groups who are concerned at this area, and we're examining very carefully our own statutory steps on that.
Okay. All right, Deputy, thank you. And thank you to the Commission representative as well. Now move on to Deputy Mick Wallace, please.
Yeah, and Jim just says he has two questions and he wants to get out of here. So will that?
Is that okay, Chairman? Yeah, thank you very much, Chairman.
By agreement.
Yeah.
Bullied me.
I didn't bully him.
What do I complain to?
First of all,
give me your number there.
it would nearly been quicker to let him go first. But first of all, thanks very much for coming in. I just want to ask you about the investigations you can conduct under Section 137 and 138 of the Act. Like, there's a power under Section 137 to require people to attend before the authorised officer. Has that power been invoked?
Thank you, Deputy. So the Section 137 investigation is, I suppose, a step that can be taken in the context of the statutory inquiry, and the statutory inquiry is commenced under Section 110. So Section 137 essentially represents I suppose, a particular set of powers which can be invoked by authorised officers. In particular, an authorised officer, once Section 137 is triggered in the context of an ongoing statutory inquiry, the authorised officer can, for example, hold an oral hearing and has certain powers in relation to more extensive powers than the standard powers of authorised officers under Section 130 to compel evidence on oath and a range of other particular powers. So that power has not has not been activated to date, but we keep under review the exercise of our powers, and each inquiry will depend on the context, the level of cooperation by the organisation in question, the manner in which we need to go about gathering evidence and collating information in relation to the scope of the particular inquiry. So the question of what powers are exercised at what point will really be very much context dependent.
The power to, I suppose, require somebody to attend before you hasn't been invoked, and the power to conduct an oral inquiry that hasn't been invoked.
No, neither of those powers have been invoked.
And the authorised officer, that is a role performed by somebody from within the DPC, is that correct?
That is right. At the current point in time, in the context of all of the 49 investigations that we presently, or 49 inquiries, I should say, that we currently have open. However, the legislation, the provisions in relation to the authorised officer do make it clear that there is scope for persons other than staff of the Commission, depending on whether they are deemed to be suitably qualified, also to be authorised as authorised officers. And I should also say, in the context of the GDPR and the provision for a cooperation and particular joint operations which can be carried out between European data protection authorities, that potentially those provisions in the 2018 Act will allow for the authorisation of officers from other European DPAs to take part in our investigations.
Okay. And what did these, just find the 17 investigations that are ongoing into the big tech companies, under what statutory provision are those investigations taking place?
They have all been commenced under Section 110.
And what needs to be done in order for that to be transposed into a Section 137 investigation?
So Section 110 refers to, I suppose it's the overall framework of a statutory inquiry. The Section 137 investigation, as I said, is a particular step.
So just that step hasn't been taken as
no,
of yet?
No, it hasn't been taken.
Okay.
And it will very much depend on whether or not we decide we need to exercise those additional powers that Section 137 allows for.
Thanks very much, Chairman.
Okay, thank you, Deputy O'Callaghan. I suppose we now go on to Deputy Mick Wallace, please.
Thanks, and thanks very much for coming in. I'm sorry I'm a little bit hoarse. We've been talking about this stuff now for, I don't know, it must be nearly 2 years, so it seems a lifetime. And I still don't understand it all, so I actually don't envy your jobs. I think I'd rather be pouring concrete with my bare feet now than doing your job. But listen, we've prepared a number of questions, and the questions are not a criticism. I'm looking for more information, and a lot of it kind of springs from our encounters with the government ministers while we've been debating all this stuff over the period. So I've broken them into a couple of different sections. 30% of all complaints from the 25th of May 18 to the 31st of December 2018, and 39% of all complaints made in the same period under the pre-GDPR Acts were access rights complaints. Access rights complaints were by far, in terms of the numbers of complaints received, the biggest issue. I wonder, do you have a further breakdown of the different types of access rights complaints? How many related to the 1 month time limit for organisations to comply with access requests? Are any statistics available on the length of time between receiving a complaint and initiating an investigation and the time to completion? I wonder, how does the DPC enforce the 1 month limit for organisations to comply with access requests? What enforcement options are available if an access request complaint can't be resolved amicably, as was in the case of case study 5 in your report? I appreciate that DPC is the de facto European regulator and that you have an enormous amount of work to get through. However, according to anecdotal evidence provided to me by various people who have made access rights complaints to the DPC is slow to even deal with a complaint that a data controller has simply ignored a subject access request. If these procedures and delays are a result of insufficient funding, then the funding of the DPC obviously should be looked at. If it's something else, maybe the complaints handling perhaps needs to be examined. Now, I know you were talking numbers there. I think you said 135 present working with you, 160 by the end of the year, and you're saying 190 by the end of next year. But is it enough, I suppose, is my question. I'll stop there for a minute and I'll just answer those two.
Okay, thank you, Deputy. Please.
I might hand over to my colleague Jennifer O'Sullivan to address the first part of this question.
Jennifer, please.
Okay, thank you, Deputy, for those questions. So in terms of access requests and the complaints we receive about them, a significant proportion would be in relation to the 1-month deadline being missed. A further significant proportion would be on the completeness of the information provided. We can follow up with you with the specific breakdown on figures if that would help. In terms of the length of time between the DPC receiving the complaint and initiating activity, yes, you're right, that would partly depend on the level of resources we can apply. And as we increase our resources, we are actually seeing a shortening of that time period. So we're tracking that performance measure very carefully now and seeing a slight reduction in it. Further to Deputy Chambers' question earlier and my colleague Anna's response to him, the question of funding and resources, it really relates to the level at which we can simultaneously handle complaints and enforce. So generally the length of time takes, there are certain finite parts of each process that need to be run through, but we can certainly do more simultaneously with more resources. So you asked specifically about the length of time between receiving the complaint and initiating an investigation. When we receive a query or a concern or a complaint from an individual, we obviously check first to see if it is within our competence, is the issue relating to data protection. And after a certain assessment of that, generally we would initially seek to try and amicably resolve the matter between the individual and the organisation. Access requests particularly tend to turn on their own facts. So often by us intervening and engaging with the data controller and the individual, we can actually achieve a vindication of the individual's rights very quickly and ensure that they do receive the complete set of data that they're seeking from the data controller through our intervention. So not all of these complaints would ultimately end up as investigations, and particularly so for access requests where it seems like the issue is specific to the case. So they would have a very small proportion that would reach a kind of a statutory basis like that. And my colleague Anna might follow up on that one. But that's not to say that when we do achieve amicable resolution of the specific case, we would always look and examine the issue in general with the data controller, and it wouldn't, having achieved amicable resolution of the actual case, would not preclude us from continuing to examine the issue in a more systemic way. And Anna might want to follow up on amicable resolution in general.
Yes, thank you, Jennifer. Yes, amicable resolution, as has been outlined in the context of a number of different case studies in our annual report, is actually a very valuable method by which we can achieve the vindication of data subjects' rights. And our experience is that the majority of complainants to our office are satisfied once they have received the information that they've been looking for, say, in the context of an access request, or they've been able to achieve erasure of information, for example, or whatever type of right it is they have been trying to exercise against the data controller and have had no success with. Our experience is that it generally isn't necessary to take further enforcement steps. However, you asked about what enforcement methods are open where, for example, we are not able to reach that amicable resolution, either because the controller isn't inclined to allow the data subject to exercise their right, or potentially sometimes because the complainant just is not prepared to accept an amicable resolution. And that may relate, I suppose, to the general backdrop to the complaint, because very often we do find that data protection is the prism through which a lot of consumer issues come to the fore. For example, in relation to overcharging by banks or telephone companies, that can be a frequent occurrence. And so there may be a more complicated background to the complaint. That means that the complainant themselves just isn't prepared to engage in that amicable resolution process. In circumstances where we are encountering difficulties with a controller in getting them to comply with the request by the data subject, we have particular powers that are set out in Section 109, subsection 5, in relation to the issuing of enforcement notices, which we can use to direct the data controller to do a number of things, such as comply with a particular request or notify a data breach to an individual if they haven't already done that. And then more broadly speaking, we have a range of enforcement, of more general enforcement powers where a complaint might turn into a statutory inquiry.
Thanks. Page 45 of the annual report gives an update on the Public Services Card investigation. It states that the draft report of the investigation was issued to the Department of Employment and Social Protection for comment in August 18. The draft report, we are told, contained 13 provisional findings. I'm curious about the word provisional. You might be able to elaborate on it. And what way are the findings provisional? In what way are the findings of the DPC in the draft report subject to change? I'm familiar with the statutory inquiry workflow as outlined in the annual report, but I'm curious if the findings of the DPC at this draft report stage might change based on steps taken by the data controller, i.e. the department, to address, for example, issues of coerced consent or the lack of a legal basis for processing in the period between receiving the draft report and the DPC's final decision. Or is it the case that the findings are provisional because the data controller might offer a further defence against the findings contained in the draft report? I have some concerns that the process involves a certain amount of collaboration between the regulator and the data controller. Perhaps you could comment on that. In relation to the statutory inquiry workflow, as detailed in the annual report on page 28 to 30, am I right in saying that step number 6 in the process, in which the DPC decision maker notifies the DPC draft decision to other concerned EU data protection authorities, is necessitated by Article 60 of the GDPR, which refers to cooperation between the lead supervisory authority and the other supervisory authorities concerned? Is the statutory inquiry process, including, for example, the EDPB dispute resolution phase of the process, the same for all DPC statutory inquiries? Also, is the same process or workflow for these types of investigations used by all data protection authorities in the EU? Is this process applied in a consistent manner across the EU, do you think? A spokesperson for the DPC late last year said that only a summary of parts of the final report of the Public Services Card, which is deemed to be in the public interest, would be published. Can you elaborate on the term public interest here? How could it be in the public interest to conceal aspects of the investigation? Do you not think by not publishing the full report there will be a problem with transparency in terms of the investigation? As I see it, this investigation has real potential to be a definitive or even landmark statement by the DPC on data processing in the public sector, irrespective of which way the DPC rules on the various different elements of the investigation. Last month, during Minister's questions, the Minister, Regina Doherty, told me that, and she said, I would have my legs cut off, she says, if she went against the clear instructions from the DPC not to release the draft report. The Minister didn't understand my question. I was actually asking about the possibility of publishing the DPC's final decision, not the interim or draft report. But could you clarify if the DPC did in fact instruct the Minister not to publish the draft report, and if so, why?
Thank you, Deputy. So firstly, just to address the queries that you've raised in relation to the Public Services Card report and our ongoing investigation into that, I think I would prefix my comments by saying that there is a limit to how much we can say in relation to an ongoing investigation, and members of the committee will be aware of case law in relation to issues around prejudgment and the issuing of comments which could potentially raise concerns around bias or predetermination of those issues. The investigation is very much still ongoing. You have referred to concerns around collaboration between the regulator and the data controller, the department in this context, and I would like to absolutely refute that comment and say that there is absolutely no collaboration. We are an independent regulator. We have to investigate the facts of the issues that are to be determined in relation to the scope of an inquiry. We do that in a wholly independent and impartial manner. And the steps that we follow in relation to any investigation are steps that must accord with the right of all of the parties to any given process to fair procedures and to procedural safeguards. So in the context of that report, which was issued on a provisional basis to the department, the report is said to be provisional because it allows for the right to be heard of the department, which, as you will be aware, is a fundamental aspect of natural and constitutional justice within our legal system. And so that kind of phraseology of provisional is used to denote the fact that submissions were allowed to be received. An opportunity was given to the department to make submissions in relation to the report, in relation to both the provisional findings, so that they could address any issues that the department considered not to accurately reflect the factual or the legal situation, so that we could take account of those in our further consideration and in finalising the report. And in the context of, I suppose, the overall timeline for that report, as our annual report refers to, we received a very significant volume of material by way of submissions back from the department in response to our invitation to make submissions, around 470 pages of documents. So we are currently in the process of reviewing that volume of material. I should also say that in the context of the overall scope of the investigation that is ongoing, this hasn't been a static inquiry. There has been an element of dynamism to it, in that certain things have changed during the course of our investigation. And just to give you a couple of examples, one of the issues that is, of course, being investigated relates to the question of transparency and information that is given to data subjects by the department. And in the course of our investigation, the department has published a comprehensive guide to use of the public services card. It has also published, for the first time, a consolidation of the relevant social welfare legislation in this area. So the scope of the inquiry has had to move to take account of these changes. Equally, you will also be aware, in relation to the use of the public services card and driver licences, in the course of our investigation, practice has changed quite considerably. And for example, between June 2017 and August 2018, a PSC was required to sit the driver theory test, but as of August the 20th last year, the PSC became just one of a number of forms of acceptable identity confirmation in that regard. So, as I say, the investigation is a somewhat dynamic one in its nature. We anticipate that the investigation will conclude within the course of this year with the issuing of our final report to the department. In relation to the issues that you have raised around publication of the report, the investigation in relation to these issues has been conducted under the prior legislation, so the Data Protection Acts 1988 and 2003, and our powers in relation to publication are constrained and determined by the extent of the powers that are set out in those acts. So unlike the 2018 Act, which allows for express powers of publication under section 141, there is no equivalent section within the previous legislation. However, that's not to say that if the consent of the department was given to the publication of that report, we would very much be open to looking at publication of all of that report, with the caveat that obviously if there was any confidential information that wasn't amenable to publication, we would have to look at that. But overall, we have no objection to the publication of that report once the finalisation concludes.
And will you make a recommendation to the department to publish it, do you think?
We will certainly draw attention to the issue to the department, and we will raise the issues that have been addressed by yourself in this committee hearing.
If a company uses facial image matching software to match a photograph of a person to other photographs or digital images stored in a database, would you consider this to be a processing of biometric data? Do you think this kind of facial image matching meets the definition of biometric data in Article 4.14 of the GDPR and the reference there to specific technical processing? The Data Protection Commission issued guidelines last year in relation to biometric data. One type of biometric data described by the DPC was, and I quote, raw images consisting of recognisable data such as an image of a face or a fingerprint. This appears to be in agreement with Article 29, Working Party example of biometric data, which specifically mentions a photograph of a face. It would seem obvious to me that photograph is a raw image consisting of recognisable data such as an image of a face. So can you confirm or clarify the DPC's position in relation to the biometric nature of a photograph? Are photographs biometric data?
So the issues that you have referred to around the processing of biometric data concern the processing of special categories of personal data under the GDPR. So I might hand over to my colleague, Mr. Ryan, just to address the processing of special category personal data in more detail.
Yeah, so, Deputy, under Article 9, it sets out conditions for processing of special category data, and of course biometric data is included within that. Article 9 is considered a condition, a derogation. Effectively, in order to process sensitive data, you need to rely on one of the derogations set out in Article 9.2, and you'll see what measures need to be implemented, whether that's explicit consent, whether it's in the public interest. They actually distinguish public interest here. They say in the substantial public interest. So when you're looking at processing of biometric data, and in particular facial recognition software, you are perhaps getting into this area of Article 9, and you will need to satisfy a condition under Article 9 to do so. I haven't looked at it personally myself in terms of assessing the case you may be aware of. I think you're just mentioning it more in general. So a lot will come down to what type of processing is taking place. Sometimes processing, for example, takes place in an airport where they're actually not trying to attach any personal information. They're measuring a queue. And is there actually processing the personal data by measuring a queue, individual coming into an airport and leaving through the security gates? So there's different types of processing taking place, and how are they matching facial to other data is a very important distinction between just looking at X moving through an airport queue, where they're not trying to actually match that data with anything else. So I think a lot of what will come down to is the process in itself, the nature of the process, and whether there's matching of data with other personal data like name and so on and so forth.
Thanks for that. In a special investigation part of the annual report, I was glad to see that you have initiated a Section 110 inquiry into surveillance by state sector for law enforcement purposes. Limerick City and Council's Smart CCTV project, which now seems to be abandoned because it will not comply with GDPR and Data Protection Act, despite spending about $350,000 on the project. Obviously a crazy waste of money, and we've raised the problems with the scheme previously in the Chamber and warned about the lack of a legal basis for the project. The project proposed deep learning and artificial intelligence to be overlaid on a network of cameras that could count footfall, keep a record of the registration of every passing car 24 hours a day, and that could recognise faces and patterns. Section 38 of the Garda Síochána Act clearly specifies that CCTV schemes should only be authorised for securing public order and safety in public places. Yet Limerick Council published proposals for the project stated that their scheme would be used to monitor tourism and, bizarrely enough, for animal control. I hope that the DPC's decision in relation to CCTV schemes and law enforcement surveillance, whenever it is published, will deter another public body from wasting so much money on a mass surveillance project that doesn't have a legal basis. Last year I asked a parliamentary question in order to try to establish if there were limits in terms of the technology that could be used as part of the Department of Justice community-based CCTV scheme. The annual report indicates you are investigating automatic number plate recognition cameras, for example, as part of this inquiry. Section 31D of the Garda Síochána Policing Authority and Miscellaneous Provisions Act bestows responsibility to publish guidelines in relation to CCTV cameras on the policing authority. I wrote to the Policing Authority last year in March in relation to the use of automated number plate recognition and facial recognition cameras as part of the Department of Justice community-based CCTV grant aid scheme. The Policing Authority confirmed that, rather strangely, the authority had not yet issued any guidelines under Section 38 of the Act, and that neither had the Department issued guidelines before the authority was established. As far as I am aware, no guidelines have still been issued. But the Policing Authority also stated in its reply to me that the authority has no role in relation to the technical specifications of CCTV cameras. Neither the Minister nor the authority seem to have any responsibility for this, it seems. I submit an FOI request to the Policing Authority to try to find out more information in relation to any work they may have done on the CCTV guidelines. In a comparative research paper on CCTV from 2017, one suggestion made by the Policing Authority was that a code of practice might be a better idea than the required guidelines, though this would require Section 38 to be amended. But the authority also suggested in the papers released via FOI that the job of drafting a code of practice would really be a job for the DPC rather than the Policing Authority. In an email from September 17, the Head of Legal Policy and Research at the Policing Authority addresses the statutory role in relation to CCTV. The email states, "There is a limited value in the Policing Authority putting in place such guidelines. It seems to us that most of the issues in relation to monitoring of CCTV come under the remit of the DPC. Could you confirm if you have had any contact with the Policing Authority on these matters? And also, can you clarify if the DPC intends to make a decision in relation to the technical specifications of surveillance equipment it will permit to be used? I mean it in terms of how powerful or intrusive such equipment might be."
Okay, who would like to have a go?
Thank you, Deputy. You raise a lot of very pertinent issues and something we are keenly aware of ourselves. And there's quite a few questions within your list, so I'll hope I get to them all. And if I don't, please. Yeah, but please, it's more to give you an outline of what we're doing. So obviously you're aware that we have taken upon ourselves an investigation in terms of the whole community CCTV area. This is as much to find out for ourselves what's happening on the ground. As I referred to early on, we have 31 local authorities who are operating the scheme in different manner, perhaps, albeit that there's a code of practice in place. This is currently all under review, and our whole inquiry, it will assist in that regard. So the inquiry has been outlined, the status, we've provided an update in our annual report where that's at. It will take time because we effectively have to engage with 31 local authorities about this issue. I've noted in a report the committee here has done in terms of rural policing just this month that it's a very important issue in terms of rural policing and so on and so forth. So we're obviously cognizant that we need to get this right. And one of the issues that's come up in that is accountability, who is responsible, and administratively who is responsible for the data that is collected. Now, as part of that investigation, perhaps other technologies are going to come to the fore. As you mentioned, automatic number plate recognition is one. And I know you've picked one example of it. In terms of the legislation, we would expect the legislative provision to allow for that. In the absence of a very specific legislative provision, you're then looking at carrying out appropriate assessments in advance of processing of data, particularly the data in terms of number plate recognition and matching that to individuals' names, addresses, and so on and so forth. So even in advance of anything in legislation, an assessment would need to take place as whether it's appropriate to use this type of technology and in what procedures and in what ways will this technology be used, for what purpose. In terms of the Policing Authority, we have had interaction with the Policing Authority over the last few years in terms of their strategy statements, in terms of meeting with them. I'm not specifically aware of the code of conduct or the guidance that you refer to in the legislation, and thank you for that. That's actually good to know. In terms of codes of practice, however, it's worth noting that the Commission, the DPC, doesn't have a role in terms of doing a code of practice unless it's actually specifically prescribed in law. We are under Article 40 of the GDPR basically tasked with encouraging codes of conduct, and we very much would encourage in this situation a code of conduct in terms of community policing to be updated, reviewed and published. It's a great document in terms of accountability. It's also a great document in terms of transparency, because anyone can read the code of conduct and understands what the local authority or what the community CCTV scheme is doing. Also, as you're aware, most of these community CCTV schemes are actually done by way of public consultation in advance of setting it up. So there's an opportunity for the community to raise any objections or to raise any issues in terms of their use. I think I've pretty much got it all, but in terms of guidance, we would obviously assist the policing authority in terms of guidance, but if the guidance is a matter for them, then perhaps we can say, well, listen, are you going to do anything on it? And we can assist in that process. From our own point of view, we are currently at a final stage of drafting guidance for CCTV, and I'm hoping that guidance will be issued soon, very soon. But that guidance will be more generic. It won't specifically deal with CCTV from a public sector point of view or use. And I suppose just to follow on, what we're hoping to do is do generic guidance around CCTV, talk about some of the technologies, the new technologies that are being used, in terms of state surveillance or surveillance in general. And then what we'll do is we'll drill down on that guidance, so we'll have specific guidance in CCTV for local authorities, community CCTV, for the AGS and how they use CCTV. And that's kind of our plan in terms of getting awareness out there, setting the parameters of what is appropriate in terms of its use, and also getting the message out that when you're rolling out large-scale CCTV monitoring, that it is done following an appropriate and very detailed assessment that mitigates risk and includes safeguards to ensure that the data protection rights of individuals are protected.
In case there's any, I won't hold you up any longer. If there's any questions I put in that you haven't answered, you might look through them and you might send us on some written correspondence. I have a fellow in my office called Adrian Norton, and he eats GDPR for breakfast, so he'll be very disappointed if there's any questions missing. Thanks very much. Thank you.
Thank you. And again, just if you were to respond to any of the questions subsequently, if you direct them through the clerk in writing, who will circulate them to all the members. That's just the way we approach it. Deputy Clare Daly, please.
Thanks, Chair. I've a nerd in my office as well, but some of her questions have already been answered on this, because I think Jack made some points that I was going to raise, and then Mick made a few others. But just firstly on the tech companies, and you were talking about 15 investigations. Was there not 16? Has one been completed? And no, it was always 15, was it?
There was another one opened at the very start of this year to make 16. So in the annual report we refer to 15, I think, but we've opened a further one at the start of this year.
But none have been completed or anything?
None have been completed, because all of those ones would need to go through that EDPB consultation process, but none of them have actually even reached that stage. Given the nature of each of the inquiries, they're very significant in scope. We're examining many of these issues for the first time under the legal framework.
And the Google one that you mentioned in terms of France, the reason why you didn't do anything further on that was because they hadn't got their headquarters here at the time or something, was it?
The complainant had submitted the complaint to the CNIL, the Data Protection Authority in France, and because Google had not set itself up as a data controller anywhere in Europe, and indeed not in Ireland at that point, it didn't fall under that one-stop shop model, which uses Article 60, potentially Article 65, as Deputy Wallace mentioned.
You couldn't really have done any more, because you'd indicated that you were going to follow up on them.
So we were in very close dialogue with the CNIL and with other EDPB members to examine the particular situation. It wasn't envisaged in the drafting of the GDPR originally that we would have the situation where a company had indicated it intended to set up a controllership but had not yet done so. And in that intervening period, a significant complaint being received. I
suppose that wouldn't happen now. I mean, it's just the fact that France might have been investigating, given the scale of this breach and how egregious it was, like it would have warranted, if you like, if Ireland was in the role as, in effect, the European data controller at that stage, the fact that France were looking at it wouldn't preclude you from dealing with it, would it?
No, so in a scenario, if another data protection authority had received an equivalent complaint, and that particular one related to the setup process that an Android phone uses and the effect downstream on advertising and so on, if another data protection authority had received a complaint during that intervening period, no, they would not have been precluded from investigating it, and any data protection authority, depending on its own national legislation, could have examined the issue in its own right as well.
I suppose it's true to say, and again, it's not a criticism of any of you or the Commission or anything, but the Commission itself has come in for some pretty scathing criticism in terms of how it regulates, I suppose, the big tech, the multinationals and so on, you know, from the Schrems case and so on. His assertion was that you could have taken action directly against Facebook rather than the convoluted sort of route via the courts here and that. And we know, for example, people like, you know, the former German data protection person made the point that, you know, Facebook goes to Ireland because, sure, of course they'll get away with murder in Ireland, like, you know, in terms of it's the area with the least levels of data protection. Now, I know we're improving and we've beefed up on that, but in that context, I suppose, and in the context of the shocking revelations about the close relationship between the Irish political establishment and how the likes of Facebook, for example, viewed the Taoiseach of our country as basically a puppet that they could manipulate in terms of getting light touch regulation. We are in a uniquely sort of peculiar situation in Ireland. On the one hand, we have these giant multinationals which are located here. Some believe because of light touch data, clearly for taxation purposes as well. And because they're located here, ye in essence have become the EU data regulator. So it's a very challenging role, and any of my criticisms are in no way critical of any of ye individually or anything like that. It's a recognition that it's a really hard job to bridge, I suppose, and in the context that you're largely funded by government as well. How do you deal with, I'm looking for a bit more, how do you deal with that conflict? Like, is it not the case, or would it be better, say, if you were funded by Europe, given that role and the sort of potential conflict? I'm not explaining it properly. And how do you cope with that? Like, how would you describe your relationship, I suppose, with the permanent government, the civil service, that inner thing? How does that work? Is it an area that could be improved a bit more? I'm conscious that it's new in some ways. So is it the right setup, or is there something we could do more? Have you perceived a difficulty there in terms of your I know you're not, nobody could possibly come in here and say, yes, we have a difficult relationship with government. I'm not saying that, but you know the broader point about accountability. Is there a better way we could be doing it? Has it emerged as a problem for you, particularly in the context of the big tech multinationals and so on?
So, just in terms, I suppose, of our own role, which we take extremely seriously, and the most serious aspect of that is our independence. And we would always seek to protect, bolster, reinforce our independence, both in our regulatory activities, but also in our work as an organisation in terms of the priorities we place on particular matters of enforcement, the priorities we place on some of the other non-investigation contexts in which we work, the more general supervision, and indeed the work we do around encouraging compliance. So we would always seek to protect that at its core. And indeed the GDPR is very emphatic on the independence of supervisory authorities in general terms and in specific terms. And just, I suppose, the GDPR itself is the answer to that requirement for supervisory authorities to act independently. We have one common law in Europe, and we have a whole framework that has been established to ensure the consistent application of that law. And that would include the level of sanctioning. It would also include the level of decision-making around the gravity and seriousness of infringements that are found. So Deputy Wallace referenced Article 60 and Article 65. There were very robust and rigorous procedures in place within the GDPR to ensure that consistent application of this legal framework. Article 65 has not in fact been put into practice yet. We have had fewer than 10 Article 60 decisions across the EU actually achieve completion. So the EDPB is very much still testing the waters of these procedures, but in summary, that whole framework is there to ensure that every data protection authority in Europe is applying the law consistently and in its findings.
I know, and it is kind of, I know it's difficult when it is new, like to see, but there's nothing emerged sort of as a red flag in terms of what we might need to do in beefing up legislation or anything here in terms of independence, or you're kind of happy enough that teething problems aside, or, you know, natural run-in time, things are basically working out okay, or?
I suppose the situation is as challenging as we would have expected given the entirely new legal framework, given, I suppose, simultaneously the fact that data protection and privacy is now part of public discourse in the mainstream, whereas a few years ago it wouldn't have been. In terms of budget and funding, the other change that we're undergoing this year is to we will become our own accounting officer for our own funding, so we will be separate from the department in that regard from next year. So we will have our own vote. It's not that that speaks directly to our independence as a supervisory authority, but it further underlines our independence as an organisation from a government department. So that change is also coming through in the coming months.
And just in terms of, obviously you've power to levy fines under the new legislation. Now, from reading, am I right? No fines have been levied yet. So I'm kind of wondering in terms of that, given that not all of the investigations would necessarily be terribly complex or, you know, long-winded, why hasn't there been any fines? And, like, are you absolutely satisfied that none of the cases which have been concluded, say, for example, met the threshold for a fine? And how much discretion do you have in that regard? Like, you know, has there been any internal discussions around those issues regarding whether a fine should be levied? Because I think we would see that as an effective mechanism for correcting behaviour, and if you send a strong signal, well, then that's likely to get the message out clearer. So.
Thank you, Deputy. So in relation to fines, there is a particular process that must be followed as set out in the legal framework that's established under the 2018 Act, whereby there was a decision made in the context of a statutory inquiry that is opened under Section 10, and that decision is one as to whether or not there has been an infringement of the GDPR or the 2018 Act. And then connected to that, the next step which the Commission must take when exercising its decision-making power is to decide whether or not, if there has been an infringement, the type of corrective power that should be imposed. And as you correctly refer to, administrative fines are actually one of a range of different corrective powers that can be imposed by the Commission, and these corrective powers are the same across the whole of Europe. And in terms of I suppose the process that has to be followed, I referred committee members earlier to the statutory inquiry process which we have outlined in our annual report, and I think it's really important to underline that there can't be any shortcuts taken in relation to the statutory inquiry and the decision making that happens at the very end of that inquiry, because ultimately our decisions as a quasi-judicial body must be robust, they must be legally sustainable. There are very extensive powers in terms of judicial remedies that are open to any party that is impacted by our decision. So we are very mindful in having plotted out those procedures over and above what is in the 2018 Act, that we must take full account of the right to due process and to fair procedures, which are all referenced in the GDPR as well. So I suppose all of that is to say that there can't be any shortcuts taken in relation to our inquiries. It is a process that must be followed, and at the very end of that process, once the fact-finding stage has been completed, once the analysis of the facts has been completed, and once that official decision-making function has been carried out, the end point will be a determination as to whether or not a corrective power or an administrative fine, amongst others, should be imposed. And I suppose I would also refer you to Article 83 of the GDPR, which kind of sets out the circumstances where there has been found to be an infringement of the GDPR, the circumstances that must be taken into account by a data protection authority across anywhere in Europe, where they are deciding as to the level of the fine that should be imposed. So particularly important here are issues around the nature, gravity and duration of the particular infringement. And the GDPR also emphasises that the whole purpose of administrative fines is to be effective, dissuasive, and they must also be proportionate. So these are all factors which will be taken into consideration in the context of that decision-making phase, which will come after the investigation phase of our statutory inquiries concludes.
It doesn't really address the question, though. My question started, if you like, where you ended there. I'm specifically talking about cases which you have concluded and done fairly in accordance with the legislation, I would assume. You've weighed up all the stuff and all the rest, and presumably you found breaches, which you have. And my question was that in the context of all of those cases which you fairly and transparently went through, you didn't find any case where you deemed it necessary to issue a fine. I'm wondering how many of those cases met a threshold of a fine, whether fines were discussed in that context, and maybe the reason for some of that, because we would see it as quite an effective remedy. So.
Thank you, Deputy. So I think it's important to distinguish between the complaint handling function that we perform, which relates to the vast majority of issues that come into this office, into our office, separate from the statutory inquiry. So with the complaint handling, our obligations under the GDPR are to handle a complaint and to investigate it to the extent appropriate. And in complaints handling, we're always focused on vindication of the data subject's rights. So it may be that having, I suppose, concluded a complaint handling function and having obtained an outcome for the individual, we then go on to consider whether or not issues that have been raised in the context of that individual complaint are issues which are systemic to the data processing operations of a given organisation, or which pose a particular high risk to individuals who are also users of services or products by a particular organisation. So there is a decision to be taken by us as to whether it's appropriate when we're faced with a set of circumstances that might indicate that there could potentially be systemic or high-risk issues around processing, as to whether or not we commence a statutory inquiry. It is in the context of statutory inquiries that we can impose administrative fines as a range of corrective powers. And as we've referred to, there are currently 49 statutory inquiries open to us. So in the open by us at the moment. So in the context of those statutory inquiries, it is absolutely open to us at the end, if we find that there has been one or more infringements, to impose a corrective power or another administrative fine. If you contrast that with complaint handling, there are a different range of methods by which we can use to close off complaints. So it may be that we have issued advice to the data controller if we find that their systems aren't necessarily compliant with the GDPR, but the complaint itself lends itself to amicable resolution or to another of the different types of outcomes that are contemplated by Section 109, which sets out what steps we can take in handling a complaint.
Okay.
Yeah, and maybe it's me. I'm sorry, but is the answer then that it's only the statutory inquiries that give you the power to have a fine, and as you haven't completed any of them, that's why there's no fines?
That's right.
That's the answer. Okay, thanks. That's the short version on that. Okay, yep. Just on that, I was a bit scared, to be honest, with regard to some of the points made in relation to the public services card investigation, and I found the response a little bit chilling, to be honest, when Mick was asking the questions. I mean, the fact of the matter is you've been investigating this since 2017. Now, I know that you've said, oh, things have moved on and all the rest, and the driving licences and that kind of thing has been sorted, but in fairness, you identified well over a year ago the, I suppose, illegal basis upon which the department was operating this public services card. We know, as a result of the dialogue in society, a number of changes have come about, but not as good as they should. I mean, let's be clear, the Attorney General gave legal opinion, which we know this time last year led to the Minister for Transport telling the RSA they couldn't be relying on the public services card for driving licence, but they still kept doing it for another 5 months after that in flagrant breach. So the Data Protection Commissioner is on the record in August 17 saying that this was a pressing matter that needed urgent attention, and our systems needed to be sorted at that stage. And here we are now in sort of March 2019, and it hasn't been concluded. And I don't get that, and I know the exchange that you had with Mick in terms of the full report and all of that. And again, I'm not entirely clear on that. I mean, are you saying? I mean, I'm not clear why it's been delayed. Like you said, the department gave you 470 pages that have to be analysed. That seems like the sort of general sort of civil service, and not from you, but the approach to bogging down inquiries, dump a pile of information late on the day and bog them down and that sort of stuff. But that said, like 470 pages isn't actually an enormous amount given the length of time this investigation has been going on. And so, like, when can we expect it to be concluded? And I'm a little bit confused. Like, I know you said you don't have the express powers to publish, but do you think there's a legal impediment to your publishing, or did I understand you correctly in saying to Mick that you believe that you'd have to get the permission of the department were you to publish the final report? I wasn't, fully sure on that,
So in relation to publication, yes, it is the position that we would have to consult with the department to confirm that they consented to the publication of the full report.
You can't publish, is it?
Well, as we have said previously, we intend to publish a summary of it, which we believe would be necessary in the public interest.
No, I know that, but if we'd like to see the full report published, but is it the legal position, or your understanding of the legal position, that you must get the permission from the department to do that?
Yeah, that's our understanding of the legal position, and that is the position that we have applied in relation to other reports, including audit reports that we have conducted over the years. In relation to the comments that you've made in relation to the length of time around the inquiry, I would reiterate some of the comments that we have previously made and that we have outlined in the annual report, which is to say that there are a range of quite complex legal issues that are under consideration in the context of that report. We have considered a very vast volume of information, both publicly available and which has been provided to us in the context of those submissions. And that includes information that has come not only from the department itself, but information that we have had to consider in the context of the use of the public services card by other government departments. And I suppose in connection then with the further steps to be taken, it is absolutely vital that we follow fair procedures in each and every inquiry and investigation that we conduct, and that we do not short-circuit those procedures. And so that involves allowing the right to be heard to the party that is going to be potentially impacted by any decision or outcome of our investigation process, and that applies as much to government departments as it does to any private or commercial actor. So the need to take account of to allow the opportunity for submissions to be made where there could be potentially findings in relation to the law is an absolutely essential element of the steps that we have to take in any investigation or inquiry.
I don't think anybody would accuse you of short-circuiting or not giving enough time, given the fact that the Data Commissioner was on record in August 17 and saying that she and her staff, presumably all of you, have strongly conveyed your views, and I'll quote her words, on numerous occasions. This is her saying this in August 17, on numerous occasions to the Department of Social Protection in a number of fora, that there's a pressing need to deal with these. So, there is no short circuit, and this has been going on a long time, and the indications were that the report would be finished in April 2018, and it's now April 2019, and there are, as you say, incredibly serious issues around it. Just briefly, in terms of, say, do you know how many bodies are using the SAFE2 PSC system, and how many of these are requiring that this should be the sole form of acceptable identification? And if you don't know, and I don't expect you to, would you be able to provide that information to the committee later on? That would be helpful, I think.
I don't have that information to hand at the moment, Deputy, but we'll certainly
consult internally on those issues. And I know it's a kind of bit like Mick's, but in a recent answer to a PQ to me, the Minister for Social Protection reiterated her view that that I suppose the view of the department, I suppose, that Save 2 PSC photo is not itself biometric in nature, and that the department does not collect or share biometric data. Do you agree with those two statements?
I think, Deputy, in the interests of preserving the integrity and the process that we're involved in at the moment, I will only say that that is being considered in the mix in the context of our investigation and against the backdrop of the information that we are considering.
Those issues are part of
Yes.
that process that's underway at the moment. Okay. And just the last thing is, and I know, the 1 minute I stepped out of the room, I think you might have answered this, and if you did, I'm sorry. But it's about the digital age of consent. I know Jack had raised questions about that. Obviously set at 16, despite our best wishes, despite the wishes of every single child protection expert in this state. It was set at 16, and I note in passing, but I think in the context of the robust discussions we had here, it's worth putting on the record that one of the main movers who was advocating behind the scenes to raise, because originally we had got acceptance on a digital age of consent at 13, but to raise the age to 16, advisor to, and quoted by certainly not the Fianna Fáil representatives here, but other Fianna Fáil representatives when the legislation was going through the House, but that individual is now involved in a private company that's seeking to produce patented age verification biometric technology, something for which a larger market was created, obviously, when we raised the age of consent to 16. How interesting is that? But anyway, not surprising. That aside, how is it being implemented? Is it working? How is the age being verified? Do you know, are companies using technical fixes or what's going on in terms of that verification? I know obviously in the US that under their COPA Act, companies are doing things like, you know, parents scanning copies of their credit card or government IDs or whatever. So what in the main is there anything like that happening here that you know of, or do you, you know, how do you see your role in that? Like, I know you've a consultation or something underway now.
Yeah, and thank you, Deputy. I think that the consultation is really central to examining the issues that you raised. So one of the questions that we are posing within that consultation is around what the appropriate age of digital consent should be. We have noted, we noted at the time the representations that were made, which I think you're referring to, by various charities and children's representatives and other organisations around the age of digital consent. I suppose it's worth noting, as you're aware, that under Section 31 there is a review to be carried out in relation to the age of digital consent after 3 years, and certainly the consultation exercise that we are undertaking we hope will provide us with valuable feedback and outputs around the opinions of stakeholders in relation to what an appropriate age should be, and that also is connected, I suppose, to the exercise of children's rights as well, which is another very pertinent issue under the Data Protection Act. In relation to the operationalisation of the age of digital consent, so there are mechanisms such as age gating which are used by organisations, and I suppose in order to verify children's age, whereby children might be, or users are asked to input their date of birth and are only given a certain number of attempts within which to enter a date of birth that would be calculated to make them over the age of digital consent. I suppose this is an issue that lots of different sectors and indeed jurisdictions have struggled with, and I suppose one of the issues that we're examining is how do you actually have or implement an effective verification method in relation to age, bearing in mind in particular that if you're trying to collect the age of your users in order to identify who is a child, the necessary implication of that could be that you end up collecting age-related information on all of your users if you're an online platform, and that in itself raises issues around excessive collection of personal data under the GDPR as well. So these are very complicated issues, and we're hoping that our consultation will help us to throw some light on them in terms of best practices for organisations.
hugely challenging, and it obviously raises major, serious data concerns in terms of hoovering up parents' data and all that. But I'm just wondering, I know there was one system mentioned recently about proposing scanning children's retinas to verify their age and this type of stuff, which is just obviously genuinely mad and scary at the same time. Have any breaches of legislation been reported to you in terms of age verification, or would you know? I mean, obviously you're keeping an eye on the overall consultation, but has there been any?
Yeah, Deputy, you mentioned the COPPA Act in the US, which has been in effect for several years, I think about 20 years, and methods of verifying age in the US, which are culturally acceptable, those equivalent methods have not gone down well across Europe. So we have had some complaints from parents who've been asked to provide information which they consider to be an interference of their privacy. So in terms of breaches, we haven't actively identified any that we're working on, but we have received complaints because of the very method of attempting to get the verification.
But you could investigate that complaint further, or do you need more legislation?
So we are looking at those complaints, absolutely, but
yeah.
The complaint in those cases is that the parents or the guardian's privacy has been impeded or infringed, whereas the legislation itself, in terms of verifying the data, we haven't received complaints that the organisation offering online services hasn't attempted to.
Well, that was precisely something that we warned about when we lost the battle on the age of consent at 13. But in any case, sorry, my last area is just in terms of.
You said that a few minutes ago.
I'm saying it again, and I'm not, and I'm sorry, and I know, and I'm not. And we're all in good.
Proceed.
All the company that's still here is all good. Don't worry, all good. No remarks been made here.
Well, she was referencing me on the age of consent.
Anybody, it wasn't representing you.
Let me clarify. She was including all of us remaining.
Yeah, absolutely, 100%. Just know the last thing was just about data subject access rights and the Gardaí. And I suppose I'm asking in terms, do ye have any role with regard to data on individuals held by Gardaí? And I mean it from the context we're aware of a number of cases where people seek information about themselves from the Gardaí and haven't got the full facts because of supposedly security reasons. I suppose, is there anything people can do there? Or is there anything ye can do to help them? I'm aware of people who, for example, haven't got a job as a result of, say, a guarding vetting application where they've got some information back from the Gardaí, but other information was denied to them on security grounds, which they believe to be erroneous, because if they knew what the information was, they feel they would have an ability to challenge that, because they're pretty sure they never did anything that would warrant them being blocked, but they have lost job opportunities in that regards and haven't had the full information about themselves to enable them to challenge it on the grounds of security. So is there anything you can do in that situation, or where is that at? Are they right doing that, or, you know, there must be some way around it, presumably. I don't know.
Yeah, I might take that, Deputy. Like, effectively, there's a few things. First of all, you look at the whole vetting procedure in terms of what's disclosed and what's not disclosed, and we're actually looking at that currently in terms of updating guidelines in line with the GDPR and the provisions in the GDPR around Article 10 data, which is data that relates to allegations of criminal activity or offences and so on and so forth. So that's in train at the moment. The second thing in relation to the Gardaí, a lot of the times what's happened in terms of these types of subject access requests or partial response to a subject access request is that we would look at it through a complaint, or, as we've done in the past, through audits to see exactly what's going on. So sometimes we've looked at the individual complaint itself in terms of, well, what information is not being shared, and we can obviously carry out an inspection to determine whether the test that's been applied for not disclosing the full set of data is correct. So, for example, a lot of the times you would have noticed in the past is Gardaí may not disclose certain information that would prejudice the investigation of a case. because to do so would really jeopardise that objective. So we have to look at in the complaint at what the data is not being disclosed is, and then make a determination on that. So it's very difficult without that knowledge to make a determination. In terms of the Gardaí, they have a very good DPO unit set up, obviously following the GDPR, and also internally that data protection unit would need to oversee how those requests are being handled and met. So it wouldn't just be an individual Gardaí or Garda that would make that call. It would actually have to go through a certain procedure in order for the data protection unit to also ensure that procedures and processes are being met under the GDPR.
You can actually get to see the full file, can you?
If required, but we could also do it, like an audit is a more rounded inspection of what's going on in terms of procedures. I mean, it depends on the terms of reference of an audit. But if a complaint was made where there was an impasse where we just didn't know what was being shared, we couldn't obviously investigate the complaint fully. So we'd have to probably carry out an inspection to see what the information was.
Lawfully, they couldn't, I suppose what I'm trying to find, they couldn't hide behind national security and saying, or, you know, security considerations.
Well, again, it depends on what is in play. So, for example, state security, if that is the argument being made, that would probably fall under our old Acts, which is the 1988 Act in terms of state security. In terms of the Gardaí and operations, typical operations, that would fall under the Law Enforcement Directive. And we have our powers then, as Anna has outlined earlier, in terms of investigations and inquiries and so on and so forth. But I think a lot of the time, if an individual is not, feels they are not getting access to the data, for whatever reason, they can make a complaint to the office, and of course we'll then have to handle that complaint.
There's no impediment, say, to stop ye going and asking the Gardaí. And I'm thinking of another similar case now where people have been denied, and we've had a number of tragic cases here of people applying for citizenship in Ireland who've been told that, you know, come along to the ceremony, or happy days, you're going to be an Irish citizen, and then shortly before the event getting a letter saying, oh, sorry about that, we're putting that off for a bit. And then they say, well, why? What happened? And they say, oh, well, look, we've got some information and we're just looking at it. But they can never see what that is. And we've saw monumentally, I know the chair is involved, but could you see what that is? Because we're just told, oh, we've heard something and we're looking into it. And this could go on for years now, and the person is denied.
And it's a very difficult situation for individuals. And of course, we're all about ensuring that individuals have the right transparency about how their data is being processed and everything else. And that's a massive piece of work we're doing in terms of ensuring that information notices are clear, people are aware of how their data has been processed. And it kind of falls into the Murray report and the recommendations of the Murray report. I know that's in relation to surveillance and telco data, but that kind of oversight and ensuring there is proper oversight in terms of if someone is saying, no, we can't share the data on the basis of it'll prejudice a case, how do we know that? What notification is being mentioned, what authorisation is being given. And the Gardaí do have those checks and balances in-house, but ultimately an individual who feels that why would the Gardaí have something they're not sharing with me, I have no clue why. Perhaps then a complaint could be sent to our office, or a query could be sent for us to check that. We do have that relationship with the Gardaí. We work with the DPO units with the Gardaí all the time. A lot of what they're doing in the AGS now is updating their systems. They've implemented a really robust assessment package, so a lot of what the Gardaí do is underpinned by data protection impact assessments. And they really are implementing the Law Enforcement Directive in full in terms of their assessments, in terms of their appropriateness assessments, and in terms of all their procedures. So there will be checks and balances internally to assess whether they're doing things right. But obviously, if an issue arises where an individual feels that they're not getting the full amount of data that they've asked for, that there is recourse to figure out whether the application of the law is being carried out in an appropriate manner.
Oh, that's really helpful, and thanks for that. As if you're not busy enough, which I know you are, you're going to be busier now as a result of opening that door.
But what we try and do, like, that's the whole point of what we're trying to do, is obviously there may be an individual case, but we can't just suddenly run for every individual case. We have to learn from that case and then get applied across a standard of what is expected, so we don't get complaints anymore. And I suppose from my own end, engagement, it is trying to get that message across. Let's get it right before the fire starts.
Well, that's great, and thanks to everybody, and we look forward for the other answers that are coming later. Thanks very much.
Thank you, Deputy Daly. And Deputy Daly herself referenced the fact that a number of her questions had been taken by colleagues previously, and she's just done the same to myself. In relation to Innis, and I just wanted confirmation in terms of the Naturalisation and Immigration Service, they are absolutely accountable to yourselves in relation to any issue that you would wish to raise. And those who are applicants for consideration by Innis in terms of their status and standing here in this jurisdiction, they're also entitled to the same protections as we as citizens are entitled to. That is the case. Yes, well, thank you for that. Just in relation to a last couple of points, and there aren't too many that haven't been raised, but I notice in the opening remarks, Anna, that you put on the record, the DPC's remit as a regulator applies regardless of industry. And you go on later in point 9, referencing the 15 inquiries in relation to the multinational technology sector, and that there are a further 33 domestic statutory inquiries under consideration. They've been referred to in the course of the exchanges here this morning. Can I ask if any of those domestic statutory inquiries apply to any of the banking institutions here functioning in this jurisdiction? Are you able to indicate if any of the banking institutions are indeed the subject of any of the inquiries of a domestic nature that you're currently addressing?
So the balance of those inquiries, the 33 domestic inquiries, 31 of those relate to the CCTV investigations that we have running in relation to the use of CCTV and other types of electronic surveillance by the local authorities. The balance of the other 2 inquiries, one of them relates to a series of data breach notifications made to us in relation to Tusla, and so we're examining the security issues around those data breach notifications. And insofar as the financial sector is concerned, we certainly do receive an awful lot of complaints from consumers around banks and insurance companies in particular. Data breach issues are a very salient issue for that industry, and a very large proportion of the data breach notifications that we receive relate to banks and insurance industries, and it's something that we are looking at the moment to decide whether or not there is merit in opening statutory inquiries of our own volition rather than being complaint-led inquiries in relation to that ongoing stream of breach notifications, because from what we can tell from analysing the breach notifications that come into us, organisational security measures remain a really big risk, and a very large number of breaches which happen relates to disclosure that shouldn't have happened. So, for example, bank statements, insurance policies being sent out to the wrong address or to an old address. So that's something that we're actively targeting in terms of our further statutory inquiries on the domestic front.
Yes. Well, you know, I think it's an area that needs particular address, and not only in relation to the forwarding of material to a wrong address or whatever is the case. They're the much more serious issue. And, you know, it's not only, I mean, domestic is in inverted commas here. I mean, the incidence of selling on mortgages, which is a significant issue of address here also in these houses. But what does that entail? That entails the selling on of all of the data relevant to the borrower. Now, a borrower presenting at any financial institution, and the experience heretofore would be a high street engagement with local presence of any of the banking institutions. And there is a knowledge, a recognition factor, and while a lot of the decision-making has been centralised and taken from the high street representatives of the respective banking institutions, the fact of the matter is that people signing up for these arrangements, whatever the small print, had no idea or concept that their information would have been open for sale on the open market to vulture funds or whatever. And I have to say that the numbers of people who have reflected their great upset, disquiet at this. And let me just underscore, there shouldn't be a distinction, because I think it's an issue that needs address substantively. But we shouldn't for a moment believe that the mainstream, the main banking institutions, they're not just selling on non-performing loans or underperforming loans. They are selling on, for whatever reason, fully performing loans. Fact. Now, you know, if somebody enters into an arrangement with a banking institution and signs off to borrow, to purchase a home, or whatever might be the case, and they're performing in line with the agreement with the bank throughout, and then they find themselves in the situation where the bank notify that they're selling on, and they appeal, and the appeal is rejected. I can absolutely attest that this is the case. And I'm somebody who formerly worked in a banking institution in this country. I'm saying that this is a really vexed issue, and I cannot emphasize enough, you know, selling on of the loan, it's the selling on of the individual data in tandem. It's all going off as a package. And we don't know even if the information is retained in the jurisdiction. Invariably, that's not the case. The vulture funds, et al., you know, are international operators. And that's not what people here understood they were getting involved in the first place. I think it is a very, very serious issue. And, you know, I would urge the Data Protection Commission to give serious consideration to address of this area, because there are, in my opinion, I won't put a tooth in it, flagrant abuses, including of the nature that I've just recounted to you. It's inexplicable, and that is all I can say in that regard. You talk about, you know, that ye might, rather than reacting to a request or whatever, initiate a statutory inquiry. You know, how are statutory inquiries initiated? How are they done? Is it of your own volition, or are you suggesting that there is a request process that may have given rise to any of the 33 domestic statutory inquiries currently in train, or any in the future? Could you just clarify the methodology that you employ?
Yes, of course, Chairman. So there are two types of statutory inquiry that we can take under Section 110 of the 2018 Act. We can take a statutory inquiry of our own volition, or we can commence a statutory inquiry which is complaint-led. And there are a range of factors which will influence our decision as to whether or not we commence an own volition inquiry. So, for example, if we are seeing trends or patterns which would point to particular issues with either a sector or a specific organisation, which would raise kind of wide-scale concerns around the processing of personal data, in other words, pointing to systemic issues, that would be something that would be very significantly factored in when we are considering whether or not it's appropriate to open an own volition inquiry. Again, so volumes of data subjects affected, along with the different types of processing operations and the different types of data that is being processed as well, because obviously there are special categories of personal data that under the GDPR merit particular protections. So if there are certain subsets of data that fall into the mix there, and that would pose higher risks to the rights and freedoms of individuals with regard to their data protection. But then again, that's another issue which would weigh very heavily in our consideration of whether or not to commence a statutory inquiry. Equally, it's not just our trends in terms of complaints that come into us that have a bearing on how we decide where to apply the very significant resources that are required to carry out statutory inquiries. And so we may have indications from civil society that they believe that there are issues with a particular organisation or a particular sector or industry, and there are a number of privacy advocacy groups that are very active in this area. Equally, issues can be brought to our attention by the press, by elected representatives, of course, as well. So there's a range of sources from which we can be alerted to particular issues. And again, even internally within our own ongoing monitoring of issues, breach notifications, complaints, trends being raised in terms of the queries that come into our information and assessment unit, all of these will be factored into the mix.
Well, thank you for that. Just a last couple of questions. You know, there was a reference in relation to policing, and Cahill responded accordingly. But, you know, we as a committee have given a dedicated address in the course of this year's series of hearings to the whole post-Brexit situation. So my question would be, do you anticipate any impact on your role by the advent of Brexit, be it either a crash out or by agreement? From a justice perspective, we've had representatives here from An Garda Síochána, from the PSNI. Are there possible implications for cross-border policing cooperation and the sharing of information on individuals in the event of the worst-case situation presenting, in terms of data protection, data sharing, a critical part of the cooperation between the two police services on this island? You know, it would have wider implications. I mean, from this committee's point of view, myself and another colleague represent our parliamentary institution on the Oversight Committee across Europe of Europol. You know, it's not something that I expected you would be able to comment on, but this is an important area. So I'm taking it from the domestic point of view, the island of Ireland. Is it something that you've given any thought to, consideration to? What can you tell us, please?
Thanks, Chairman. I might answer the question on Brexit generally first, and then hand over to Cahill to speak directly to the exchange of information between policing authorities on the island and across Europe. So the DPC has been very heavily engaged in Brexit preparations for the past several months, and indeed it's a very active topic of conversation with our colleagues in the EU and the European Data Protection Board. The transfer of personal data outside the EU is a central element to EU data protection law, and it's taken very seriously because of the relative the standards of protection of personal data being so high in Europe. To not have those safeguards in place would undermine it. So the DPC has been issuing guidance, as you may know, to organisations that seek to transfer data from Ireland to the UK. Over the past several months, we've been doing that both ourselves and via the government communications channels. And the EDPB has also been issuing guidance on that. We're also working with our UK counterparts in preparation for the potential impact to live cases that are cross-border in nature. On the transfers question, there are several mechanisms that are available for the transfer of personal data outside the EU, and if the UK leaves without a withdrawal agreement, they will be in that situation of being considered a third country. For regular organisations, the simplest and the quickest method to utilise would be standard contractual clauses, and we have templates for those on our website. There are other organisations who choose to use a mechanism called binding corporate rules, and then when it comes to transfers by public bodies, there are particular provisions in place, and the DPC has been involved in recently authorising some of those as is required by the GDPR. So Cathal might speak to the specific question on policing exchange of data.
Thanks, Jennifer.
Yes, Chair. I suppose, first of all, Brexit's on everyone's mind. It's certainly the case in our own office, and the legislation that's following, or administrative arrangements that's following, we're receiving. And it's an ongoing consultation in terms of different arrangements being put in place. In terms of the policing side of things, it's kind of, the framework is there in the Data Protection Act. And if you look at sections 96 to 100, these are the parameters within which you can share data. And without getting into the specific provisions, you would go through. So first of all, there's obviously not an adequacy decision in place, which is something the Commission can approve, and that's something that may come later down the line. But the big thing in relation to sharing of data is ensuring that the safeguards and the same rules apply when you share data to a third country. So standard contractual clauses do this for you, but you can have arrangements in place, administrative arrangements in place that, provided they are specified appropriately, can actually act as another way of ensuring that appropriate safeguards are implemented and ensuring that there is a similar level of protection to the data that is provided in this country as in line with the third country. So, for example, we're looking at issues where we're analysing whether those safeguards are put in place. Rather than just one line, it gets into a very detailed level of what data is being shared, how is it being shared, what oversight is there to the data that's being shared. And provided these safeguards, and there's many more, are implemented, we would take very much a practical approach in terms of Brexit, because we do have a long-standing relationship with the UK. We have mutual assistance that's been in place for quite some time. I know that would fall by the wayside in terms of a Brexit. But also, it's very important to note that there's a data protection office in the UK, the ICO, who has been a leader in the field in terms of data protection, is heavily involved in data protection at an EDPB level, who also would have to leave the EDPB on foot of a Brexit. But nonetheless, they have been at the fore in implementing a law which effectively brings all those provisions of the GDPR over into the English legislation. Obviously, there are some divergences due to sovereignty if Brexit happens and so on and so forth. But the core elements in terms of the protection of data is there. There's oversight, there's an ICO, there's a regulator. So we have to be very pragmatic in understanding that these structures are already in place. So it's really a matter now of deciding, well, what level of data is being shared, how is it being shared, and what level of oversight will there be to this sharing arrangement or these sharing arrangements. Another thing you'll note, especially when you look at which provision they go for, whether it's section 98 or 99, there will be a function for the DPC in terms of ensuring that reporting requirements are done, so we could go and inspect whether the documentation that's been shared is appropriate, in line with the administrative arrangements or whatever arrangements are put in place. So there will be a proactive involvement of the DPC in terms of monitoring those sharing arrangements. Again, I go back to the fact that our friends, the Data Protection Officer Unit, the AGS, will be well aware of these provisions, and they will be trying to figure out which one is most appropriate to them in terms of their everyday work and in terms of their interaction with the UK. Clearly, they're the ones who are going to make the decision, and we will help them in that decision in terms of what's required, what level of data needs to be shared, the date and time of the transfer. Also, retention is a big issue, ensuring that if you share it to a third party or a third country, it's not then shared beyond that third country, and if it is, how is it being shared beyond that third country, and so on and so forth. So there's a level of transparency required, which is appropriate to the function of the AGS, and we would be the body that would reflect and review those data sharing arrangements under whether it's 98 or 99 of the Data Protection Act. So I think it's very possible. I think we have to be very pragmatic given Brexit, and the Commission, the EDPB themselves, I know from a general data protection regulation standpoint have effectively said that. that we need to look at how derogations would be used. But ultimately, if we're looking at some form of derogation, it's not ever the solution. We should be looking for a more permanent solution. Obviously, the Commission and the UK may in the future look at an adequacy decision, which would clear this whole matter up. But in the interim, we shouldn't be relying on a derogation for the next 4 or 5 years until something like that happens. We would need to probably set in motion some more permanent solution rather than simply relying on a derogation for every data sharing arrangement.
Okay, Cathal, I appreciate that very much, and welcome the fact that this is an issue that you have been addressing. That's very, very important. It's with the, here we are on the cusp, perhaps, and it's quite alarming to find, where there are so many gaps that people are only just saying, oh my goodness, what should we be doing? I mean, this is going to impact right across the board. People just do not have a sense of the scale of this, the scope of this. It's going to be huge. The last little two little things, I'll bunch them together. And you talked yourself there, Cathal, just in relation to that last reply. In relation to regular engagement with the different companies, and we'll take specifically, the area of the international or multinational technology sector. What does your engagement with them entail? I mean, we'll say, what have I got in my mind? I'll explain what I have in my mind. I have HICWA in mind in terms of the HSE. Are you a HICWA? Do you carry out unannounced visits in terms of your, be it audit, be it inspection, be it inquiry? Give me a sense of the nature of this relationship with the Facebooks of this world. Do you carry out unannounced visits, or is that simply not the way that things work?
Thanks, Chairman. So I suppose our relationship with these big multinational technology companies is multifaceted. I suppose at the hard-edged enforcement side of things, we have our statutory inquiries that are open, and I mentioned that we haven't considered those to be investigations under the kind of which give us more powers, and we haven't used unannounced inspections in those inquiries to date. The nature of the engagement with these companies on these particular statutory inquiries is quite formal. There is a significant amount of correspondence which relates to the fair procedure that we must adopt in these inquiries. Anna mentioned the right to be heard, the requirement for these organisations to be allowed to make submissions at the various stage of the investigation. So it's quite a formal, written type of engagement in that, when we're engaging with them in that context. Separately, the GDPR introduced a requirement whereby where an organisation is considering introducing new processing that requires personal data to be processed, it must carry out a data protection impact assessment. It must mitigate the risks that are associated with that. If it finds that it still, for business or whatever other social reasons, wants to carry out the processing in the future, but it hasn't been able to mitigate all of the high risks, they're obliged to come and speak to us. So that's a different kind of engagement, which is quite formal in its own right. Separately, we engage quite formally with these organisations when we receive intelligence or media reports or submissions that are brought to us, I suppose, in a pre-inquiry stage. Again, that kind of engagement would be a combination of in-person meetings, written correspondence, us reviewing submissions they make to us on the matter, so a combination of those kinds of dialogues. And then we would have other reasons to meet with them. Perhaps they want to give us an update on their general data protection activities. Particularly in the lead up to GDPR, we would have several meetings with the big companies in that context, whereby they wanted to give us an update on their preparations for the GDPR. Those would generally be in the context of meetings where we have a discussion with them. They might bring to our attention new products that they were considering or that were further down the line, and we would have that kind of engagement with them in that context.
So the unannounced visits haven't started yet.
No, we would have to examine in the context of a particular inquiry whether there would be value to
No,
it.
I appreciate
Yeah.
that. No, I appreciate that. But here we are, and this is absolutely the last one. I'm getting worse than Clare Daly. In the course of your address to us, Anna, just at the outset, you talked about, and I just quote from New Trends, point 8, in light of the requirement on the government to consult the DPC in relation to certain new legislation. And you go on to indicate that you have reviewed and provided observations on new and draft legislation, with 25 pieces of primary or secondary legislation having come before you over the 7-month period, I suppose, from the inception of the GDPR to the end of the year. I guess that's what that's referencing. Now, new and draft legislation, the biggest body of legislation that goes through these houses is scrutineered in this committee. We do committee stage of the greatest body of legislation passing through the houses, justice and equality. The requester in this instance, I presume, is the government department. But while I could understand, your responses going in relation to draft, which may not have even presented in terms of the general scheme coming before the committee, when I hear the point about new legislation, well, my colleagues and I, we are the legislators. Government may be the initiators, but I have never, and you've indicated 25 pieces that you've responded to, I, as chair of this committee, have no recall of ever having received any feedback in relation to legislation from the DPC. I'm wondering, is that the way things should be? Is that appropriate? If we're not the requester, but, no particular section, in my opinion, legislation is the business of the houses, the Dáil and the Seanad. Deputy Daly and Deputy Wallace initiate legislation they call private members' bills. We deal with them all the time. Government-sponsor bills, we deal with them all the time. I'd have a degree of confidence that if Deputy Daly had requested a DPC opinion or whatever on a piece of legislation, she would share it. And if it was new legislation that had actually got to committee stage, it wouldn't be withheld from us. So I don't see why government should be different, because they are the initiators of proposed legislation from those of us who are broadly labelled or perceived to be opposition voices. So I wonder if you'd like to comment on that. My own sense of it is, if you are there to carry out a specific function, well, I think as legislators that we should be privy to all the relevant information to inform us as to the suitability, the consequences, the concerns, if any, in relation to all legislation. I don't think anything should be withheld from our eyes. We have a statutory responsibility and a public role and responsibility as the people who make law. So I'm wondering, and I'm concluding with this, in responding to such requests in the future, would you think it appropriate to release your replies to the members of the houses or the respective committee perhaps? But my own sense of it is that it should be the widest possible audience. So I don't know how you'd like to just respond to that.
Yeah. Thank you, Chair. It's actually a very interesting point you make. I suppose when we say 25, see, our function in consultation is set out in Article 36 of the GDPR, and it's basically consultation to happen prior to a legislative measure or a regulatory measure on foot of a legislative measure. So it has to happen in advance the processing of data. Now, when the timing and the appropriate timing for that in terms of a consultation with ourselves is really a matter, we'll say, for the department to determine, or even if it was a private member's bill, for the individual who's sponsoring that bill to determine when is the appropriate time to consult with the Data Protection Authority under Article 36. To be fair, anecdotally, what's happening is the individuals are coming to us, departments are coming to us early. Almost as a policy and almost a sketch of where they feel the legislation is going. So we know there's movement in terms of legislation. It hasn't gone to heads of bill stage even, because they're worried that in a heads of bill stage that the policy approach is simply a red line issue for the DPC. So I suppose sometimes appropriately they come to the DPC early to determine whether their general approach being taken is actually going to will not contravene data protection law. And those figures we presented would incorporate some of those engagements, which is a very early stage in the process. It's almost at a policy development stage. And I suppose we are very happy to engage in that level, because I suppose there's no point in going down a rabbit hole in terms of data protection for us then to turn around at the publication of a bill stage to say, listen, this is just untenable. But in terms, we've looked at it before in terms of publishing all our replies. But the problem is that our replies may have to be collated together over a period of time to get a sense, because sometimes what happens is we only get a question about a specific policy approach that is intended to be given legislative underpinning. So instead of looking at the bill as a whole, or a piece of legislation as a whole, or a heads of bill as a whole, we sometimes only get a policy approach of where they're going, and we may just give obs on that. But we certainly have been looking at consultation and publication of our responses, because not only will it help the department out, it gives transparency, and other departments then learn about the approach or the way the Data Protection Authority has viewed a certain matter. For example, maybe creating online registers for whatever reason in your public sector body. We have given obs, for example, many a times in the recent past of our views of the creation of online registers and the publication the same on websites. And instead of the recipient of those observations obviously learning from it, I'm very happy to share them out, but I think we need to set up a process or a format in how we do that, when we do it. When is it, and it comes back to then, when is it appropriate, or what's the perfect time for a department, or if it's a private members, but when is the appropriate time to come to us to get that full overview of our position, rather than kind of piecemeal effort, which is kind of almost out of context. So a lot of the times, I note yourselves, we've been invited obviously to pre-legislative scrutiny before, and of course if we've made observations, they are collated and shared through the Department of Justice currently. But we will be making our own observations as an independent authority in the future, and certainly we're looking at, well, how do we publish our observations for everyone's benefit? And it's something that we've been considering actually prior to GDPR. We've looked at other authorities, not just in Europe, but we've looked at other authorities elsewhere. For example, even on consultation about a project or initiative, the New Zealand Data Protection Authority firmly states that we may publish our observations on our views of this project. But yeah, it's a bit like, we have to practice what we preach to in terms of transparency. So if we're demanding transparency from everyone, we also should be transparent. But it'll be great, from my point of view, as consultation, because we get our message across not just to the person who's asked the question, but to the wider audience. And that's very important, because that helps in terms of understanding, awareness, but also in particular a standard approach to data protection that will meet the requirements of the GDPR or the Law Enforcement Directive. So I'm very much open to suggestions on how that could be done in a very effective manner. I wouldn't walk away from it. I think it's an important, and rather than having other access to information, whether it's through FOI requests, which we're not, we're only FOI'd under administrative functions, not necessarily under FOI in terms of investigation and so on and so forth. But these issues are important in terms of the data protection viewpoint. and sometimes also from our own benefit by publishing our views of these matters. It doesn't get hidden within everyone else's observations. We can actually highlight what the particular issues are for us. And then, as legislators, you are then fully aware of the views of the DPC whilst you go through the various stages of the process in the Dáil.
Be it either detailed scrutiny or pre-legislative scrutiny, as the case might be, government or private member-initiated legislation. But the critical thing is, for us to carry out our function, we need to be fully informed. And I think when I listened carefully to Anna's address, I said, that's interesting. I've been chairing this committee now since 2016, and I've never seen any of the responses referenced. And I'm sure my colleagues would concur. That's their experience also. So it's not about we want to look into their copybook. It's about we want to be the best that we can be in the service of the people who have entrusted their vote to us to perform here. And can I just, one point in conclusion, you did make the point, what is the number, 20-something, 25 pieces you've responded to. Were any of them private members' bills?
No, actually, no. One was actually a bill that was almost piggybacking on a private member's bill. But in saying that, I think actually it depends. See, sometimes sometimes the bill may not go through pre-legislative scrutiny, but so it's really determining I have absolutely no problem in sharing our observations. In sharing our observations on a piece of legislation, I think that's going to see light today or come to yourselves. So it'll be a matter of engaging with ourselves and figuring out the appropriate timing for that. I don't see anything preventing us from doing that. I think so long as all parties are aware that we may publish. Not everything is going to be, sometimes we come back with nil obs because we simply have no observations to give. But obviously when there's important data protection implications to a piece of legislation, I'm very happy to if we can do it. But I'm surprised that you don't actually get sight of our views on the legislation.
Well, look, I think it's worth noting. And, you know, the reason I've raised it is in order to ensure better communication, transparency, and better legislation, ultimately, because that is our function here in the first place. So look at, I again wish to thank Cathal, Jennifer and Anna, each of you, on behalf of the committee. It has been a very worthwhile engagement here this morning. I hope we will, I mean, you're not even at your first anniversary of GDPR yet. We have another month to go. So, you know, what we're signalling by that remark is, well, we'll do this again at some point in time down the road. So, without any further ado, Gora Mila Mohigov, and for my colleague members, thank you for staying the course. The Joint Committee is adjourned until 9 a.m. on Wednesday, the 10th of April. Shin Shin.